From Port Harcourt to Lagos, from Twitter to the Senate floor, the cry for justice for Ochanya is back, louder, angrier, and more determined than ever. But this time, Nigerians are not just crying for justice, they are asking, how did we get here again? How can a case so clear, so heartbreaking, still end in not guilty? 7 years after Ochanya Elizabeth Obanje, a 13-year-old student of Federal Government College, Boko, lost her life after enduring years of sexual abuse, her story haunts the nation again. Not because she finally got justice, but because the system that should protect children showed how fragile it can be. If you are watching this, like, subscribe and leave a comment. We will unpack the old gist, the facts, the law, the voices, and what's happening next. Now let's give a backstory of this old gist. In 2018, the nation was shaking. Ochanya Obanje, a 13-year-old girl from Benue State, fell seriously ill and was later confirmed to have suffered injuries consistent with prolonged sexual abuse. She died in October of that year. The men accused were her guardian, Andrew Obuja, a lecturer at Benue State Polytechnic, and his son Victor. The story spread fast. Families, churches, and activists demanded answers. The hashtag Justice for Ochanya was born out of sorrow and rage. Investigations began, arrests were made, and court proceedings followed, but the old ways of justice moved slowly. Witnesses went missing and couldn't appear, and the prosecution case had gaps. Eventually, after hearing and delays, the Benue State High Court found that the prosecution have not proved its case against Andrew Obuja beyond reasonable doubt. He was discharged and acquitted. Victor, alleged to be the primary perpetrator, was reportedly missing and have not been found since then. The court decision left many Nigerians stunned and asking, how can this be? This is the part that a lot of people want to understand, so I'll keep it extremely simple. Once a competent court gives a final judgment that someone is not guilty, the police cannot simply pick that person up again for the same charge. The law treats the person as legally free unless a higher court orders otherwise. So how can the person be brought back to court? The only lawful way is an appeal. An appeal is when the party, often the state, asks a higher court to review the trial judge's decision. If an appeal is filed, the police may take steps to make sure the accused person is in the higher court. That is the legal mechanism that can lead to an arrest for court appearance, not public anger or online accusation. Now, what about calling someone a rapist online after the court has declared them not guilty? If the court has already discharged the defendant, publicly calling them a rapist can expose you to defamation claims because the law currently recognizes them as not guilty. That's why lawyers warn about accusing people on social media when the matter has been decided. Put in another way, the law separates emotion from evidence. Anger alone does not reopen a case, the formal legal steps do. So if Nigeria wants this case back in court, the path is clear. Petition, fund and file an appeal, and then make sure evidence and witnesses are tightly handled so the higher court can rule differently. Now, this resurgence is different because some of the Nigerians' biggest voices amplified it. Now in 2025, hashtag Justice for Ochanya is trending with a lot of celebrities and activists lending their voice to the cause. Tiwa Savage wrote on her social media, "My heart is heavy. A young girl suffered unthinkable pain at the hands of those meant to protect her and lost her life because of it. We can't stay silent. We can't continue to hide behind family titles and tradition. She deserves justice. Every child deserves safety. Hashtag Justice for Ochanya." Ira Star also posted Justice for Ochanya, hashtag protecting the girl child. A number of activists also spoke up. Aisha Yusufu raised the moral alarm about the systemic failure, and also Senator Natasha Akbuti publicly said she will amplify the petition process at the Senate and urge the family to formally contact her office so she can work with legal partners. These voices matter because they turn a quiet file on judges' deaths into a national question. Politicians notice, the media follows, and public pressure grows. Now here's a turning point that could decide the next chapter. Organizers have announced a peaceful protest for November 1st in Port Harcourt and also for November 10 in Lagos State. This rally is being coordinated by a coalition of youth groups, human rights organizations, and human rights lawyers. This protest is important not because crowds intimidate courts, they don't, but because it converts social media energy into sustained public pressure. It keeps the story in the headlines long enough for formal actors, which include the Attorney General's office, human rights lawyers, and social society groups to act. Expect this to be the moment Nigerians either turn trend into process or let the moment dissipate like many before it. If this protest matters to you, share this video and leave a comment telling us how you will follow the case. The comments on social media are also blowing hot on this cause for justice for Ochanya. Someone said they freed him. After everything, this country is cold. Another one said if Victor has been arrested and tried properly, this story would have been different. The system failed that investigation. And another said we must be strategic. We can trend justice for Ochanya, but we must fund and file the appeal. This is a call for concrete action rather than performative outcry. Now, to understand why the High Court of Benue State ruled the way it did, you must know where the process broke down. Now, let's break it down for you. The first one was missing key witness testimony. Some witnesses didn't show up and their evidence was inconsistent. In rape and child abuse trials, witnesses are critical. Another one is weak and inconsistent medical evidence. Forensic and medical records are central in proving sexual assault and causation. Gaps here and there makes it easy for defense lawyers to create reasonable doubts. Another one was the alleged main suspect, the son, who was missing and has not been found or reproduced, which shifted more burden on the prosecution to prove the guardian's culpability. And another is the delay and case management. Long adjournment and procedural delays erode witness memories and public will. When you combine these factors, even strong public belief in guilt can't overcome the legal standard proved beyond reasonable doubt. So this time, any appeal must directly fix these gaps, find missing witnesses, show up medical reports, and build a chain of evidence that the higher court cannot ignore. This time, there are legal groups and NGOs prepared to help, just like the Stand to End Rape organization. Even human rights lawyers in Abuja, Lagos, Port Harcourt has also offered pro bono support channels for strategic case, and the Office of Senator Natasha has asked the family to file a petition. Drop a comment in the comment section if you support this cause for justice for Ochanya and share this video. Now guys, if you watched to this end, do these 3 small things that matter more than a tweet. Like this video so that it can reach to much people, and subscribe, and also share this video with your friends and communities. And also in the comments, say one thing you think will help this case. We will pin the best replies and keep the conversation going.